Ladies and gentlemen, this week a dramatic fault line developed between India's top constitutional authorities, the Supreme Court of India and the President of India. Now, that very fault line has turned into a debate that questions the very character of our democracy. It started on the 8th of April, when the Supreme Court of India, for the very first time, drew a timeline for the President of India, the constitutional head of this country, on how long she can sit on bills referred to her by the governor. Now, the Supreme Court said the President needs to act within 3 months. This, of course, came after the Tamil Nadu governor sat on 10 bills, even after they were repassed by the State Assembly. In one case, the governor of Tamil Nadu had been sitting on a bill for 3 years. So, the Supreme Court stepped in using Article 140. It cleared these 10 bills and made it law without the President's formal assent. That is when Vice President Jagdeep Dhankar went completely ballistic, accusing the court of judicial overreach and warning against judges acting like a super parliament. He even called Article 142 a nuclear missile against democratic forces that was in the hands of the Supreme Court 24/7. Now, Article 142, ladies and gentlemen, is essentially a clause in our Constitution that allows the Supreme Court to go above its job description to deliver complete justice. Now, today, the President of the Supreme Court Bar Council, Kapil, Sibal, has hit back at the Vice President, saying the judiciary has every right to remind constitutional posts of their duty. In fact, he's accusing the centre of attacking the court every time a verdict goes against them and dared them to file a review, not a press statement, if they were unhappy with what the Supreme Court has done. Listen in to what both the men have said.
We cannot have a situation where you direct President of India. And on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). Article 142. Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7.
आपने कह दिया कि आर्टिकल 142 इज न्यूक्लियर फिसाइल मटेरियल, न्यूक्लियर मिसाइल। ये कैसे कह सकते हैं आप? आपको मालूम है कि आर्टिकल 142 के द्वारा सुप्रीम कोर्ट को संविधान ने यह हक दिया है। ये कोई सी सरकार ने हक नहीं दिया, संविधान ने हक दिया है to do complete justice.
So what exactly is Article 142 and why is it at the center of this fierce constitutional face-off? Now, simply put, Article 142 empowers the Supreme Court of India to pass any order it deems necessary to deliver complete justice in a case. These orders, once issued, are binding and enforceable across the country. Now, it is one of the most powerful tools in the judiciary's hands, a discretionary provision that allows the Supreme Court to go beyond black-letter law when needed to fill legal gaps, enforce its decision, or ensure fair outcomes. The court can override existing laws, compel action or evidence, and even settle complex disputes where the law remains silent. It is often invoked in contempt cases or when existing remedies fall short. So while Article 142 ensures that the court isn't held back by procedural limitations, it also raises the big question: where should the line be drawn between justice and judicial power? In this case, was the Supreme Court within its right to instruct the President of India? That's my question this evening. As my guests join me this hour, Tehseen Poonawalla, political analyst. Thank you very much. Sanjay Hegde, senior advocate, back on the show. Subhash Jha, again an advocate, joining us on the broadcast. Anurag Naidu is a political analyst. He's with us on the broadcast as well. I'm going to quickly go to the lawyers first. Sanjay Hegde, my point to you is this. One absolutely understands what the Supreme Court did when it came to a timeline being set for the governors in this country? Because we know what R.N. Ravi, the governor of Tamil Nadu, was doing. In one case, he was sitting on a bill for as many as 3 years. So was it necessary for the Supreme Court to draw a timeline for the governor? Yes, definitely, maybe. But why drag the president in? Why instruct the president of India and set a timeline for her? Is this not judicial overreach? Can the Supreme Court really instruct the President of India?
The question is, has the Supreme Court instructed the President to sign Bill X or Bill Y? No. All that it has done is to read the Constitution, say that this is the provision as far as the governor is concerned. There's a similar provision for the President. As far as the governor is concerned, when the governor has to sign, he or she has to sign within a reasonable timeline. And it has set three months. The Supreme Court has now said that the same 3 months timeline would also apply in the case of the president. The president currently is not sitting on any bills. The Supreme Court has not said, Madam President, there is this bill which is pending on your desk for more than 3 months, and therefore we shall use our 142 powers to bring it into operation. So all that the Supreme Court has done is an interpretation of constitutional provisions and said that it would apply across the board. The Vice President has been a senior advocate. I am sure that he has read the judgments. After reading the judgments, maybe the Vice President may need to read them once again.
No, Mr. Hegde, why do you say that?
I say that
because the Vice President has gone ballistic. He is calling Article 142 a nuclear missile in the hands of the Supreme Court of India.
I just wonder whether the Vice President has not fallen in love with a phrase and let it run away with the argument. It happens to lawyers at times. See, it is the same Article 142 which was used by the Supreme Court to resolve the Ayodhya dispute. In Ayodhya, it said, like, look, the Muslim side has proved its case, it's entitled to a decree. The Hindu side has proved its case, it also is entitled to a decree. Now, how do we sort it out? And therefore, it used its 142 powers even there. There have been many marriages which have broken down beyond parties are endlessly fighting. The Supreme Court has used 142 to dissolve marriages at times. 142 is given by the Constitution. The Supreme Court doesn't automatically resort to it. 142 in this governor's case was used only to say, look, there is a 3-month time limit that we have held. You had long run past it. We do not want these bills to again lay in limbo. Therefore, the date on which they were represented to you shall be deemed to be the date on which you signed it. This is our order under Article 142. I sometimes think there is a lot of what I can only call WhatsApp thinking going on. Reducing things to hashtags and slogans cheapens the debate.
No, Subhash Jha, I'm just getting in Subhash Jha because he has a contrary view to yours. Mr. Subhash Jha, has this been reduced to a WhatsApp hashtag? Is this WhatsApp talk, or is it the Vice President of India speaking like a politician more than the Vice President of, Vice President of India? I mean, how can you justify, Mr. Jha, for example, the actions of the Tamil Nadu governor, in whose context this entire judgment came? The man has been harassing the state government. The man has been sitting on laws that have been passed by the legislative. In one case, he's been sitting on a law for 3 years. The Supreme Court had to do something. This is an extraordinary case. They invoked 142. What is the problem? Now, us chakkar mein, if the Supreme Court of India has, in a sense, set a timeline for the President of India as well, what's the harm? Kuch galat baat to nahi boli na?
Shreya, I feel that 142 or Article 32 is most often than not are grossly misused and abused by the litigants, and the Supreme Court falls prey to it. There is no reason for the Supreme Court to have entertained this petition under Article 32 filed by the state of Tamil Nadu. They could have very well said that, okay, it doesn't matter if this is the issue, you should have gone first to the High Court. There is a High Court of Madras available, and there is a bench also available in Tamil Nadu, apart from having the principal bench at Madras or Chennai. So therefore, the first and the foremost, the state government should have been relegated to the High Court. Why the High Court is bypassed, and why to entertain a petition under Article 32? And so far as Article 142 is concerned, the Vice President was absolutely right. See, of course, I disagree with Mr. Sanjay Hegde. And to your question, that he was, of course, a politician. He was also a lawyer, and he is now the Vice President of India. So he understands, not that he is novice or he doesn't understand the technical or implications or legal implications of Article 142 or exercise of powers 201, 202, which has been interpreted. In my assessment, this is nothing but judicial activism and overreaching the process of law. You selectively make use of Article 32, you selectively make use of Article 142 and say that, oh, this is not a goat, but this is a sheep, or vice versa. This cannot be done, and according to me, this is an act of insubordination. Never ever happened in the history of our Indian judiciary that you comment on, you fix the timeline for the governor or for the President of India. Who are you to decide? There are several legislation, I may tell you, and I may remind my good friend Sanjay Hegde, there are several legislation in which the timelines are fixed. Now, the question which we should be posing to ourselves is whether those cases are decided by our courts during that lifespan within which they are required to be decided. And look at the manner in which the Supreme Court decides the special leave petition. In 93 seconds is the on an average time. Mr. Hegde appears in the Supreme Court quite often than me, so he would be knowing better. In 93 seconds, one SLP on an average is decided by the Supreme Court. Now, in this case, you went on to decide the issue which could have been very well relegated to the High Court and pass a long judgment and comment on the President of India and the Governor. I mean, this is not how our courts should function. The court is nobody to tell the Parliament or to the politicians, our politicians, legislature as to how they should be functioning. The timeline is fixed, of course, as soon as possible is the word used. And then even in those statutes where the strict timeline is fixed, say for example 138 of Negotiable Instruments Act, if I mistake not, 147 decides that within 6 months the cases should be decided. Yes.
Mr. Jha, are you telling me then it is perfectly okay for the governor who is not elected by the people of India to harass a state government that has been elected by the people of that state, keep them hanging, keep at least 12 bills that they have sent for your assent hanging, one of them for 3 years? That is okay. But the Supreme Court setting a timeline for the governor is not okay. आप देखिए तो बोल क्या रहे हैं?
No, I'm certainly against. Now, first and the foremost, I would not know, I may not be able to tell you as to why those bills were kept hanging. Out of 12, 2 were cleared and 10 were kept pending. Now, he may have his own reasons. Now, he may have his own reasons to give. But why to bypass the High Court and come straightway file a petition under Article 32 and the Supreme Court leaves aside all the matters? All other matters will be decided in 93 seconds. So in one of my videos, I've said that let us examine then those High Court judges who have been Supreme Court judges who while practicing as lawyers in different High Courts, how many cases they have reported. I mean, is it possible, humanly possible, to understand the intricacies of a case in 93 seconds and you dismiss the petition in 93 seconds? And whereas you choose to write a judgment which runs into hundreds of pages. Now, I have a different view, Mr. Hegde. I have a different view so far as Ayodhya is concerned. If you have exercised Ayodhya in case 142 of Constitution of India, then the judgment should not have been running into more than 2 pages. In how many cases now we and myself and Mr.
Rajya
Hegde
Hegde,
both
would you
are
want to
doing that
respond to
hijab
that
matter
charge
in
which is
Karnataka.
coming over in-
We did it
Okay.
in Karnataka High Court.
Okay, give me a minute. I'll let Mr. Hegde respond and then I'll go to my other guest. Mr. Hegde, please go ahead.
There's
I
something
believe
wrong with my
there's a
screen.
light issue there, but Mr. Hegde, I'm sure we can hear your voice.
Okay.
Koi nahi. We'll live with it.
So,
Mr. Hegde, go ahead.
No, so let me be in a purple mood, as it were. But the thing is that the Supreme Court's job is to interpret the law, and it is, whether you like it or not, that is the law. And if you want to change it, file a review petition. You know, there's a very new judgment which came out yesterday from the Fourth Circuit in the United States, where there is a similar fight. 9-0, the US Supreme Court told President Trump that they had to bring back a man who was deported to El Salvador. President Trump and his team do not like it, and they've been dragging their feet. The court there said, no, you have to show us tangible proof. That went up in appeal to the Fourth Circuit, which is the equivalent of the High Court. And please see what the High Court has said on this fight between the executive and the judicature. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment, we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been. And law in time will sign its epitaph. This is almost poetry. Look, if you start diminishing the courts, you will be seen as a lawless republic. We, sir, under the Constitution, do not elect untouchable presidents, vice presidents, governors. Be you ever so high, the law is above you. And you may like the law, you may not like the law, but once it has been laid down by the highest court of the land, you please obey it till the highest court of the land changes its mind through normal ways known to law, including review petitions.
Okay.
Do not try to weaken the institution. And
Okay.
I'll be back. I'll be back.
Anurag. Okay. Anurag Naidu, I'm just bringing you here and I am quoting what Jagdeep Dhankar has said. He says the president being called upon to decide in a time-bound manner, and if not, it becomes law. So, the vice president argues, we have judges who will legislate, who will perform executive functions, who will act as super parliament, and absolutely have no accountability because the law of the land does not apply to them. He has this observation about the Supreme Court of India, but he has nothing to say about governors of opposition-ruled states who, it seems, had started thinking that they are above the law, that they are a law unto themselves.
I think, Shreya, I think let's not make sweeping comments just on the governors or the office of the governor. That's where it all starts. Let's not make it a tutu meme. Let's not take sides. It is the Vice President of India who made these observations. He's the second most highest chair, and he's a responsible citizen. He is, our patron in a way, and he is also coming from a judicial fraternity. Just how the judiciary will not like the collegium system or Article 142 being discussed in the Parliament, and Parliament making comments of it on the floor of the House. Equally, the legislation or the system that prevails, which is elected by the people, and the Constitution, which is enshrined, and the powers that are given by through the Constitution to the governors and the president, they would not like it. right? Now you have to understand, you cannot directly demean the chair or put down the powers that are enshrined through the constitution on the chair of the governor or the president. Now you can give directives. In my view, that this is my personal opinion, it would have been fair, more balanced, if you give a directive, pull up the government, union government, pull up the law minister, pull up the parliament, and ask them to prioritize the discussions. Now, what Jagdeep Dhankar, precisely the point that he's making is, should anyone have limited accountability under Article 142 when the Pradhan Mantri himself is acting as a Pradhan Sevak? I'm just telling you, why should anyone have exemptions? And if yes, why? Another point that he's trying to make is, isn't it true that legislative powers lies in the purview of the parliament and not the judiciary? Now, there is nothing wrong. Now, you told about, in case of Mr. Governor R.N. Ravi, he took 3 years' time. Fair enough. Yeah, you're right. I mean, I'm not demeaning or not belittling your point. You have a very valid point. Now, if I were to be a mediating agency, so that in this case, I would have probably asked the parliament to prioritize the discussion, and I would have given a direction to the government to set in a frame, time frame. Instead of me calling out a time frame, that belittles the whole office in one single shot. And that is where the conflict is coming, in my personal opinion. He also made references of a sitting judge in whose house the cash has been found and the speed of investigation. Now you tell me, Shreya, are you, as a citizen of this country, comfortable and happy to see the visuals of any judge, having that amount of cash lying in the house and the speed of investigation? Please answer me. You're a responsible journalist. Are you happy with the speed of investigation? Are you happy with what has happened in this case and several other matters? There are things that needs to be improved both in legislation, both in judiciary. And this can only happen when we start listening to each other instead of, rolling up our sleeves and getting on into the fight here. How dare you come into my orbit? How dare you come into my space? Now, instead of we giving space to this kind of a conflict, let's bring in an environment where, there is an openness. Yeah. Go ahead. I would be more than happy to see the judiciary accepting the discussions of... Yeah.
Tehseen Poonawalla, the fact is this is a street fight. There is no two ways about it. At least Jagdeep Dhankar has made it that.
At the onset, just two comments I would like to make. I would like Article 142 to be used to declare that there is no dish called veg biryani, and no matter how purple you are, you can't celebrate it. And there is a massive difference between a goat and a sheep. Goat have horns, sheep don't. Goat have slight beards, sheep have wool. So if the Supreme Court does rule a difference between a goat and a sheep, it's the right thing for the Supreme Court to do. They are not the same animals. But let me come to the more serious issues. Look, Shreya, in our constitutional framework of things, neither the Parliament is supreme nor the Supreme Court is supreme. What is supreme is the Constitution of India. And both the Parliament of India and the Supreme Court of India get their powers from this book, the Constitution of India. Now, when I am tomorrow in government, I'm very uncomfortable, and I've said this, with legislative powers, slightly with courts under Article 142. It makes me very uncomfortable. Sometimes this has been misused. For example, in the BCCI case, they just sat on it, they decided what they wanted to do, and these are very, very serious issues. But 142 is also being used for great issues, the Ram Mandir being one, the bulldozer justice being the other, which courts have evoked it. What is the question at hand? The question at hand is politicians, governors who are being biased. When our forefathers envisaged the Constitution of India, the roles of governors was to be a bridge between the union government and the state, not to be political animals, not to sit on bills. Let me give you an example of the exact same bill passed by the Chhattisgarh Congress government when Congress was in government pertaining to OBCs, and the BJP government in Karnataka. The Karnataka governor signed the bill, the Chhattisgarh governor sat on it, and governors are now becoming political animals, which is against the framework of constitution. Again, I'm very uncomfortable with courts stepping into this domain, with courts telling speakers how the assembly should be conducted, with courts telling speakers how the house should be run. But who's doing it to themselves? In Maharashtra, for example, speaker sat for months on a disqualification issue. In Karnataka, also the speaker sat for months. So what is the view that the courts are taking. The courts are saying, listen, we don't want to interfere in a sovereign house, but ultimately this is affecting the democratic structure, which is the basic structure of the constitution, which cannot be affected. Now, likewise, the courts would be very uncomfortable if, say, Parliament tomorrow summon judges and say, finish off a court hearing in 3 days or 4 days. That's not the way it's supposed to be. I completely get that. But here, politicians need to also make sure that they fall within the constitution. If speakers are not following their duty, if governors are not following their duty, they're sitting on bills for months on end. Now, there is a misconception going on social media that suddenly the Tamil Nadu Chief Minister moved Supreme Court under Article 32 and the governor was pulled up. No, he actually moved Supreme Court in 2023. It's been 2 years. It's not instant justice. It's gone through a lot of processes. And many opposition chief ministers have gone to the Honorable Supreme Court asking for this role of governors. We've seen what happened in Delhi, for example. The Supreme Court came down and said, look, it's the elected government that must govern. Immediately, an ordinance was passed in the vacation, and the power went again to an LG who's unelected. Now, the basic framework of this book is democracy, the will of the people. The will of the people resides in the elected. In the union, it resides in Prime Minister Modi and his cabinet. In states, it resides in Chief Minister Stalin and his cabinet, Devendra Fadnavis ji and his cabinet, etc., etc., etc. When you take away the will of the people, let me put the foot on the other shoe. Will my friends from the BJP be okay if the President of India were to do the same thing to Prime Minister Modi? If she were to usurp his powers, and despite Prime Minister Modi being elected by a supermajority, say, no, I am sorry, I have certain powers in the constitution, I will run it, we won't be okay. Because the will of the people lies in the elected chief minister, prime minister, and their government. And that is what the courts are attempting to do. Am I uncomfortable with it? Very. When a court tells a speaker how his house should be run, it's so uncomfortable for me, because when I visualize sitting there, it's scary for me that a court's going to tell a speaker of mine that this is how it should be run. But what are these speakers doing? What are the governors doing? And they've brought this upon themselves. Therefore, it is in national interest, the political parties come together, make sure that there is a Lakshman Rekha between the executive and the judiciary, a very thick Lakshman Rekha, and politicians follow what is to follow this book. Don't do whataboutery with what happened in any other case and what's gone wrong with judges. Should there be more accountability for judiciary? Yes. I am not completely for the collegium system. Should government have some say in who comes on board or opposition as judges? Yes, they should. Maybe a public thing. Should collegium meetings be transparent, RTI driven, reasons be put out why certain people have become judges? Yes. But those are separate issues. Those should happen. And no one's stopping Parliament from legislating on that. Why does Parliament not do that? Those are issues in the nation's interest. Let's do that. Let's not throw away the baby with the bathwater. And once again, Article 142 for no veg biryani.
Okay. So, Bajja, I have to wrap the show, but there's a question that comes to my mind, so I'll end with you. My point is this. Would the reaction that Mr. Dhankar has given or you are giving on this show would have been the same had the President of India been sitting on bills endlessly once that Parliament had passed? Because after all, what the Supreme Court has said and done, given Jagdeep Dhankar's, missile against that, and then Kapil Sibal today stepping in, everything emanates from that one judgment. If it is not okay for the President of India to sit on bills endlessly, bills that the Parliament of India has passed, it is simple that the governor has no role, has absolutely no business to sit on bills that the legislator has passed. Now, if the governor is behaving like a political agent and the opposition in the state, what else do you expect the Supreme Court to do? You're being critical of them, but what else do you expect the Supreme Court to do? They will use the extraordinary powers that the Constitution has given them for quote-unquote complete justice.
Now see this judgment. This judgment is in the nature of writing a statute. You rewrite the Constitution by saying that the President of India or the governor must decide the file within, say, you fix the timeline within 30 days, 90 days. Now, doing so, you're trying to rewrite the Constitution, which is not the function of our judiciary. The only function of our judiciary is not enacting law. But in the name of writing judgment, if you start enacting law, and that's my problem, I see that the Supreme Court, in the name of interpreting a judgment, interpreting a law, keeps on foisting upon us or thrusting upon us what is known as, or the judgment is considered to be law of the land, as if they have got the power to legislate. Power to legislate is not the function of our judiciary. There has to be a line drawn. The judiciary must realize that they must leave it to the parliament to embark upon. And as somebody has said, I think Mr. Hegde has rightly, or someone has, Mr. Naidu has said, that all that they should have done is to make I agree with him that ultimately, if 3 years is too long a time, I quite agree with you on this. Therefore, ideally, they should have referred it to the parliament to decide, the government to decide, as they have done in the matter of Article 44 of the Constitution of India. How many times since 40 years, it started after that Shahabanu's case, and then Sharla Mudgal's case, and so on and so forth. So the Supreme Court did not say that, okay, it doesn't matter, you must do it in so many days. It did not do it. It only reminded, a request was made to the Prime Minister of India that time, some 35 years ago, saying that you do look into it. Similar requests should have been made at the most to the Parliament or to the Prime Minister to look into it and to see to it that such issues are important issues are not kept pending. Whosoever is in the power is immaterial.
Sanjay Hegde.
But yes, there has to be.
Sanjay Hegde,
but it is not the judicial function.
Take 20 seconds to respond to that.
Share like one.
Take 20 seconds to respond to that. That there was a way to do this. That there was a way to do this. You could have just pulled up Parliament and the governor and told the Parliament, look, within the next 3 months, fix what ASAP means and let us know and let the country know. Else we'll do it. Instead of jumping right in.
The Constitution says as soon as possible. The Supreme Court has told you what it says, what is as soon as possible. You can't go beyond 3 months. That's all. It didn't say do it on day 1 or do it on day 90. For this process, 3 months is sufficient. Beyond that, so it has not set an immediate time limit. Do it today. So all that it has done is interpretation. The court's job is to interpret. Now to Mr. Poonawalla, if the court had to interpret whether veg biryani is a biryani or not, and the court said yes, veg biryani is a biryani, whether you like it or not, you have to follow it. That's the law. You can file a review petition. You can ask for a curative. But as long as the declaration of law holds, it binds.
I will run
quickly come in. I have to wrap the show.
I will run a hashtag campaign against this, and I will have Sanjay file a review petition. But quickly, just to Mr. Jha, one quick point. Look, on the Uniform Civil Code, that's a directive principle. Right? On the fundamental right, when a matter of governance is stopped, those are two separate issues. Even in the Goa issue where the Congress could have formed the government, the governor then of Goa, she took advice not from the Supreme Court judges or High Court judges. She took advice from the Law Minister of India. So these are things that the governors themselves are doing wrong, which is taking away from the will of the people. The basis of our constitution is we the people. The courts cannot allow we the people to deter. You have to uphold we the people. Under any circumstances, whatever that be. That is the rationale on which courts are operating. Again, I'm very uncomfortable, but that's what's happening because we politicians are doing it to ourselves.
Okay. So the crux of the matter is that
the point is if politicians and authorities
and because
don't
politicians
act,
didn't decide on what ASAP means, and because the politicians have not had the time to decide what ASAP means or as soon as possible means, the Supreme Court has gone right ahead and told us that it means 3 months. Now, if the government has a problem with it, and if Jagdeep Dhankar, who's also, of course, eminent jurist, has a problem with it, well, a review petition can always be filed. We'll leave it there for the moment. Thank you very much, Tehseen Poonawalla, for joining us. Sanjay Hegde, good to have you on the show. Subhash Jha, thank you very much for your time. Anurag Naidu, thank you very much.